Morning, everybody. We'll get started here in about 5 minutes. Try to let some more people trickle in, and then we'll get started. So thank you all for joining me.
Somebody from HEC, can you confirm that the sound is okay? Okay. All right, I think it's adequate time to get started. So I'm Chris Sarek. I'm the Deputy Director, Executive Secretary for the Alcohol Tobacco Commission of Indiana. And I have the legal team here with me. Alex Vargo is a excise officer and also an attorney. And he helps me with legislation. He's been critical to getting all the stuff we're going to talk about today done. Melissa Beaucaire is our general counsel, and Daphne Whitmer is our senior attorney. She's also been a huge help in the legislature. So first thing, let's probably do some housekeeping in terms of CLEs. If you're an attorney and you're wanting continuing legal ed credit for this webinar, you get an hour and a half, assuming we go the full time. Daphne Whitmer is going to provide the CLE credit form, the request form, and she will be putting the passwords, the secret words in the chat and speaking them verbally throughout the presentation. So keep your ears open for that and your eyes open for that. And then you need to write that down so that you have that when you fill out your request form. Anybody on legal want to add anything before I get started in terms of housekeeping? Okay, so the way that we're going to organize this presentation, I'm going to go through each bill, and at the end of each bill, we'll have a question and answer period. If that ends up being too time consuming, such that I'm not going to make it through all of the material in the hour and a half, then we'll switch formats and we'll have to do questioning all at the end, and then we'll just get to what we can. If anything doesn't get answered today, feel free to reach out to us. Of course, we're always here to help. Email is the best way, given volume. Also, that way we can have a written correspondence, and it's sometimes easier to explain something in writing and be able to extrapolate and have a back and forth that way. That way it's also documented. So with that, I'm going to get started with our legal disclaimers. Obviously, we are attorneys that represent the state of Indiana. We're also state employees that represent our agency in the state of Indiana. We are not your legal counsel. I cannot give you legal advice. None of my team or my boss, Jessica Allen, can give you legal advice. I should have mentioned too, Jessica Allen is here. She's our chairwoman and our fabulous leader. So let's see. Next, we have the disclaimer regarding our operational details. So we're going to talk about how we're going to implement these bills, obviously, and this is for informational purposes. We're trying to do the best we can to be transparent and get information out to the public and to our stakeholders and to other attorneys regarding what law changes have happened and how we're going to implement them, how we interpret them at the present time. It's important to note that these things are subject to change, obviously. We may receive guidance from our legal counsel at the Attorney General's office that our interpretation of something may be incorrect, or this is how we should interpret something. So that's just to say that it's something we say today, it may change. So don't bring my words back to me in the future if something changes slightly. That is just the nature of bureaucracy and reality, really. Finally, any images we use, and I'm pretty sure this is the only one here that's wishing well, are used consistent with the fair use allowance under Section 107 of the Copyright Act. So with that, it started with 2026 alcohol and tobacco legislation. It was a really big year for us in such a short session. A lot of things happened, a lot of changes happened, a lot of substantive changes happened. Obviously, we didn't get everything we wanted done. The big elephant in the room is always going to be THC until that gets clarified and regulated properly in the state of Indiana. However, we got a lot of other priorities accomplished. And so we have a lot to do as an agency to get things implemented. And I think a lot of positive change for Hooters and our industries as well. So here is a table of each bill and the short description, and then each code site that was affected, that was amended in the bill. So I reference this back throughout the year. I know some of our attorneys do as well. It's just a useful resource if you are an attorney or an industry member and you want to say, what was it that HEA 1052 altered to impact habitual offender status or something along those lines. You can then reference the index here, and hopefully that helps you. And along those lines, we will share this presentation. We'll post it on our website along with the recording of this webinar, and that way it will be accessible to everyone. Starting with HEA 1052, this was the agency bill for ATC, for gaming, for horse racing, and it did a lot. It ended up being both tobacco and alcohol. So I'm going to start with the tobacco provisions. And excuse the clutter on some of these slides. My goal is to convey as much information as possible, both in the slides and verbally, just because I think that's the best way to use these presentations and these written resources. So the big thing from 1052 in terms of tobacco that we changed was we added a requirement that distributors of tobacco in Indiana, whether they're located in Indiana or distributing tobacco into Indiana, have to have a ATC issued wholesale tobacco sales certificate. So this is an addition to the DOR distributor certification that's already required. All businesses that are distributing tobacco to Indiana retail tobacco sales permit holders must obtain this wholesale sales certificate from the ATC by, and I'm saying November 1st, 2026. The effective date is July 1. We understand that A, we don't have the application up yet, and B, it takes time to get the word out and for compliance to matriculate back to us. So recognizing that, we have a bit of a grace period here between now and November 1st, or between July and November 1st. Officers will probably do some educational enforcement if they're out in the field and a wholesaler doesn't have a certificate. They'll let them know that it's required, and hopefully that will induce compliance. Like I said before, this is required in addition to the cigarette distributor license that is issued by DOR. So the terms of this new wholesale tobacco certificate, it's a 1-year duration, so slightly different than the retail, which is 3. So it has to be renewed yearly, and it's $100 new and $100 renewal fee, non-transferable, just like a retail TC, and it has all of the same requirements and qualifications as a retail retail tobacco sales certificate. The application will be online in My License One, same as TC's. There will be required now, and this is pursuant to a change in HE 1852 for all certificates, retail and wholesale, a requirement that a copy of the ID of at least one owner is submitted with the application, or with an ID of the applicant themselves. Idea here is that we have an identity associated with a tobacco certificate. This is targeted towards entities that are playing shell games. And it's not, if you're here today, you're probably a very compliant actor because you want to learn and you want to do what's right. You're being proactive. So this may not be geared towards you, but it is going to help you because it's going to help us track and eradicate or get into compliance some of the bad actors out there by having an actual identity associated with a TC. We can properly identify when that individual changes a location or otherwise pull some shenanigans. So in addition to a retail sales certificate, a location can also hold a wholesale. So retail and wholesale can be issued for the same location, same entity. Main thing here is that operations are maintained separately. I understand that the way that things are currently operating, there are retailers that have wholesale operations and they're sort of operated in the same floor plan. And we're going to work with our retailers. So if you have a floor plan related issue, you can bring it to us. The goal here primarily is just that there's not confusion or intermingling between the distributor and the retail operations for our officers to be able to distinguish them when they're doing an inspection. So this maintained separately issue, it's been raised to me as potentially problematic. We will work with our retailers that have wholesale operations to make sure that their business operations are not interrupted by this. The other changes to the tobacco sales certificates from HE 1852. First off, this is now new. TC is no longer just a retail. TC now refers to retail and wholesale. So the word certificate in Title 7.1 now means wholesale and retail. As I stated, you have to have a valid copy of a valid identification for at least one owner filed with every new and renewal application. And lastly, the new certificate cannot be issued. A new certificate, and I say certificate again, that means wholesale or retail, cannot be issued for a location at which a TC was revoked in the last 12 months. What this means is if you're operating a tobacco business, you have a tobacco certificate at 12 Main Street, and that certificate is revoked for bad acts, then that location, 12 Main Street, cannot obtain a new TC at that location for 12 months. There's an exception, of course, for an arm's length real estate transaction. If Bill Smith trades to Mike in Michigan, and they're completely separate entities and individuals, then that real estate can be utilized for a new TC in that 12-month time frame by that new owner. So Idea being, if you have a bad actor that has a permit revoked, what we're seeing frequently with these, again, the worst actors is that a relative, a friend is just coming in and applying for a new TC at that location, obtaining it, and then the individual, the entity, all of the same actors that were operating the revoked certificate operate the new one. This will prevent that, we hope, and that is our target outcome. A couple of new penalties are imposed in 1052 on TC violations. First off, currently a material misrepresentation of fact in a tobacco certificate application can only result in suspension. Pursuant to code, we added revocation in there in the event that a material misrepresentation in fact disqualifies an individual based on the fact that what they misrepresented was a essential qualification or condition for holding the permit. It can now be revoked. Or for any other reason that is determined at the discretion of the ATC in relation to a material misrepresentation. Secondly, there is now an automatic escalating set of penalties for violation of the employee ID requirement. I know this has been a hot topic in some of my discussions with industry when I've gone out to association meetings or board meetings and had conversations with groups of operators. The question of the employee ID requirement has come up. So the requirement again is that if you are an employee selling tobacco at a TC location, you have to have a valid form of state or United States issued identification. And if you do not have that identification when requested by an officer, then you have 5 days to produce that to the officer, or there will be a violation imposed on the permit location, on the certificate location. So as it currently stands, there is not an escalating set of penalties, and there's no like habitual offender status for that violation as there is for others. HEA 1052 changes that. Now, if on your third violation, you have an automatic 5-day suspension, and this is in a 12-month period. If you have 3 violations for this in a 12-month period, something's going wrong, right? So this shouldn't affect very many actors if things are going well out there. 4th and 5th, same thing, you get another 5-day suspension. And then if you have a 6th violation in a 12-month period, which I hope never happens, then you're going to have a revocation automatically. So idea being to put some teeth behind this requirement. That's the goal. So moving on to the alcohol permit provisions from 1052. A couple of just basic statutory updates, modernizations. There is currently no definition of organized sports competition or sports arena in Title 7.1. In order to create some clarity around those two terms, we took the definitions that are in 905 in the administrative code and the rules, and we adopted them to statute as well. There is the exception for the bouncer employee permit. So currently, as you all are aware, if you have a bouncer, a security officer, or somebody at the door who's checking ID and controlling entry, that individual under a statutory change from last session, I believe, or the session before, I think it was last session, that individual has to be a licensed employee. They have to have an employee permit from the ATC. And we ran into the question frequently, well, what if that individual is a law enforcement officer? Obviously, a law enforcement officer has the training and the certification way beyond an employee permit. So we added an exception for LEOs that serve in those capacities. So if you have a law enforcement officer acting as your bouncer, your security, your entry control man or woman, they no longer need to have an employee permit. The next change, a beer wholesaler can now deliver beer as a food ingredient to a food manufacturer. This came up in the context of fried fish, beer battered fish, and whether or not a beer wholesaler could sell and deliver beer product directly to a food manufacturer for the purpose of using it as a food ingredient. And the answer now is yes. Well, as of July 1, the answer is yes. Next change, this one is a wine retailer, whether they can have self-service. And so this is a limited allowance for certain wine retailers, those that over 60% or more of their gross revenue comes from the sale of wine. So if you are a wine retailer and the majority, 60% plus of your revenue comes from the sale of wine, you can now offer self-service sealed wine bottles for off-premises consumption. So somebody can grab that sealed wine bottle, pay for it, and consume it off-site. So that is a change, whereas, currently retail is on-site consumption. So this is allowing an off-site purchase via self-service at a retailer, where self-service is generally not allowed in that context. Next change, and this is a pretty significant change for not a lot of fanfare around it, but temporary beer wine permits that can now receive and sell mixed beverages. We talk about mixed beverages. We're not talking about Bill has a temporary permit for his party, and he's mixing drinks with whiskey and Coke and selling mixed beverages under a temporary beer wine. Now, that's not what we're talking about. We're talking about RTDs, the already packaged, the sealed, existing, already mixed beverage that is mixed in a can, right? And these are liquor-based mixed beverages. There is a alcoholic content cap on that. There's a definition of mixed beverages in Indiana code. That is what is allowed. We're not allowing liquor now to be sold under a temporary beer and wine. We're just allowing these mixed beverages to be sold. Next, there was, so everybody is probably familiar, if you're a retailer, you're familiar with the limited separation concept in a restaurant, where you have to have a wall, a barrier separating your dining room and your bar area. And the current allowance, you have to have 250,000 in food sales, I believe, to have an exception, if even that. We added a new exception to Indiana Code 7.17511, and now there are 33 or 34 exceptions to limited separation. And this is for a restaurant, that has food sales of at least $100,000 annually. So this exception is not available if you have type 2 gaming in the bar area. And obviously, if you have type 2 in the bar area and you move it to a place where it's no longer visible to minors and minors will not be present, you may still qualify for the limited separation exception under this new provision of law. However, generally, if you have type 2 in the bar area, you can't get limited separation eradicated. If you have smoking, you can't have limited separation eradicated. You can't have minors. If you are a permittee on an extension with a pending violation and you apply for this exception, it will not be granted. If you are a permittee on a corrective action plan, you won't get the exception. And if you're a permittee on PACE, you will not qualify for the exception. The idea being here that this is a privilege that we want to grant to good actors, and we want to make sure that we control this within the public interest and within the safety of Hoosiers and customers, and the motoring public for that matter. So if you are a retailer that's had violations, had issues, and you have an ongoing corrective action plan, you're on PACE, or you are on an extension with a pending violation, you haven't renewed, haven't resolved that violation, you're not going to qualify for this exception. Important to note here, I know I said this in my disclaimer rather clumsily, but I did say it. We may change things as we read the law further, as we apply it to fact patterns. Things may change, right? So I list these factors here. What we plan to do is adopt a non-rule policy consistent with Title IV, Article 22, which allows agencies to adopt non-rule policies for the purpose of statutory implementation. This non-rule policy will define the final determination regarding qualifications and procedures for requesting this exception. So, not to belabor the point, but this may not be the final set of factors, but we're pretty well far into getting that non-rule policy drafted. And once it's drafted, the commission will review it, and if it's acceptable, they'll adopt it, and then it'll be published on APC's website. So look out for that. In terms of that procedure I just referenced, this is the procedure as we've currently thought of it. So first off, you have to file a request for an amended floor plan. Obviously, you're removing your parapet, your wall between the bar area and the dining area. So you have to have a change to your floor plan. You submit your request for amended floor plan. Along with that, we will provide a form that is this exception, right? because we need to collect some more information, right? We need your gross receipts from food sales. We're gonna probably ask for your gross receipts from alcohol and entertainment. We're probably gonna ask you to verify, well, we definitely need to ask you to verify that you have no gaming, no smoking. And when I say no gaming, again, visible to the minors, you have to demonstrate on your floor plan where that type 2 gaming would occur, where it would not be visible to minors, consistent with Indiana code. And then lastly, we would like to see a plan to prevent alcohol sales to minors in the context that you allow minors into your bar area. So this last bit, again, work in progress. So excuse the lack of detail, but this is preliminarily what we plan to do in terms of the requirements in the form to request the exception. Next, after you've done all this, you'll schedule a final inspection with the local board officer. The local board officer will perform that final inspection, and then you're going to submit the paperwork to wrap up that process following the inspection. Again, this is subject to change, and we reserve the rights to deny limited separation exceptions based on the public interest within our statutory authority. Next, this is a couple of new permits that were created by the legislature this session, and there are more in other bills, but this is what's in HE 1852. We have 10 new three-way permits, three-way restaurant permits for the city of Gary. They have to be located in a development area or a revitalization area. They have a $40,000 new permit fee. And before you come to the ATC, if you're in Gary and you're wanting to operate a new three-way restaurant under one of these permits, then you need to go to Gary first, because the city of Gary is going to have to verify that A, they approve the applicant, you as an applicant, and B, that you're in the necessary location for qualifying for the permit. Then in addition to those 10 new three-way restaurants in Gary, 1052 also created one new drugstore permit for Westfield. And then commission-related changes. This is my last slide for 1052. So if you have questions, I probably should have said this, put them in the chat. Melissa Beaucaire, our general counsel, will read the questions then into the record and will provide answers. As I provide answers, I'm going to definitely lean on the legal team to chime in and help out. Jessica Allen in particular is probably the most well-informed person on alcohol law and tobacco law in the state of Indiana, and that's not at all an overstatement of fact. So might lean on her to answer some of the more detailed operation related questions if they come up. So anyways, the commission related changes from 1052, we eliminated the bond requirement for commission employees and officers. Not really a big impact on you guys. That's just sort of an antiquated requirement. And then secondly, we introduced a hindering, excuse me, that's not in this bill. Oh yes, I'm sorry, it is, okay. Failure to adhere to a suspension or revocation or the ATC is a Class C misdemeanor. So that's hindering, right? So if you fail to adhere to an order of the commission to be suspended or to not operate, have your permit revoked, and you continue to operate at that location, then you are now subject to prosecution for Class C misdemeanor, and that's for hindering. And then lastly, this is something administrative. As you're all aware, we banned the sale of nitrous oxide in the state of Indiana last session. And in conjunction with that, we have collected a lot of canisters of flavored and non-flavored nitrous oxide. And unfortunately, recycling that stuff is wildly expensive, right? So we've had to figure out what the heck to do with it. And one of the ideas was to donate it to nonprofits that might have some utilization for it, legitimate utilization for it. And we realized that we'd be dealing drugs if we did that. So we needed to update the law to allow us to donate confiscated nitrous oxide to a nonprofit, which we did. All right. So questions. Melissa, do we have questions?
Yes, we have a couple questions. So the first one is from Kirkman. If the floor plan on file calls for no limited separation and a bar receives a notice of violation, will the bar be subject to a floor plan violation if the floor plan isn't updated?
If the floor plan on file calls for no limit, no. If the floor plan that's already on file doesn't have limited separation, then you don't have to change the floor plan to get rid of limited separation.
Chris,
yeah.
What if They are currently 21 plus, but going to all ages. That may be part of the question.
Oh, so they need to okay. They would have to request, they would still have to make a request, right? I don't know, Jessica, do you have a thought on that?
Well, we wouldn't necessarily have their food figures in that case. So if they want to switch, they're going to have to proactively tell us they are switching and get us the food figures and then get the floor plan signed off as all ages, because it probably currently says 21 plus.
Okay, very good, very good. So in that context, let's say that you are an entity as described, 21 plus, and you want to go to all ages without limited separation based on the floor, the gross sales, food sales. You need to still file the exception request and go through the process of getting the floor plan amendment. And if you don't, then yeah, you will receive a notice of violation. Thank you for that.
Hey, Chris,
Okay,
I'm going to
then-
interrupt you for a minute.
Of course.
The first code word for CLE is IMS. IMS.
As in Indianapolis Motor Speedway?
Yes, it's May.
Yeah, it is. You're right. Daphne was dressed full racing checkered flag attire on the first day of May. Go ahead, Melissa. What's next? Thank
The
you,
next
Daphne.
question comes from Ms. Rachel Schnelzer. Is there still a physical barrier requirement with limited separation?
Yeah, unless you qualify for an exception.
Okay, next is from Mr. Brett Painter. With the limited separation, will minors be allowed to sit at the bar top? Or does this change just get rid of the railing and minors are only allowed at the tables near the bar without parent or guardian?
So technically, yeah, we're becoming Illinois and Michigan and letting kids sit at the bar top. If you want to do that and you want to risk selling to a minor, especially if somebody who's 18, 19 years old, and you want to roll the dice like that, I guess you're free to do so. But the risk is on you. So let's be smart.
And that is all the questions so far.
Okay, very good.
Sorry,
I
there's
see a
one.
vending
Yeah, we
machine
just,
question. I see a
It
vending
is a
machine
couple-
tobacco question. I'm not answering that
So-
right now, but thank you, Scott. Tobacco vending machines are like a joke around here because they come up all the dang time. Everybody wants to have a tobacco vending machine. Yeah, okay, cool. So let's get to Senate Enrolled Act number 5, emergency suspensions. So the ATC now finally has the authority to suspend a permit without upfront hearing or violation of, well, a violation of any part of Title 35, the commission of a crime, plus several factors. I'm just getting ahead of myself here though. So first off, the first aspect of this bill, the first section, just took the nuisance rule in 905 IAC in our rules and then put it into Title 7.1. This nuisance rule is what allows ATC, ISCP to cite businesses for violations of criminal statute for maintaining a nuisance. So if you have a violation of Title 35, a criminal act occurs on your premises or in relation to the operation of your premises, I should say, not on your premises, but you commit a criminal act as a permit holder. There we go. That is subject to citation for nuisance. That's not a change in operations because we're already doing that. Nothing's changing in that context. It's just taking it from the rule and putting it in Title 7.1. So that's just moving an existing power from rule to statute and not in any way altering that operationally. So the emergency suspensions, as I began to explain. So now under this SEA 5 change, the commission can suspend a retail alcohol permit without a hearing if a hearing is held within 3 days of that suspension. So let's say you get suspended on a Friday because there's a shooting in your location and the other factors are satisfied. We have to have the hearing Saturday, Sunday, Monday, right? So it has to be on Monday, maybe Tuesday, depending on how you're counting. But we would have that hearing then on the Tuesday. And here's the thing, if this happens, if this emergency authority is exercised and you're an attorney representing a permit holder, you need to come to that hearing on that third day ready to have a substantive conversation about the material facts, right? So obviously a full investigation, maybe you haven't completed that in terms of collecting all of the information, but you're not going to be in a position where you can't at least speak to what happened, changes that can occur to rectify or prevent a situation like this occurring in the future, that type of thing. I'm just trying to, and I don't see this being used at all, like often, like maybe once or twice a year at the most, because it's got a lot of conditions that are imposed on the ATC in terms of using it, but also the grounds or the times that we're going to want to exercise this authority are really dire situations where you have a location that's clearly a threat to public safety, or appears it may be based on actions or activities that occurred on the licensed premises, right? So again, kind of getting ahead of myself, but that hearing has to be held within 3 days of the suspension and come ready to actually talk about the case. There has to be ATC has to have a reasonable belief that a felony occurred on the licensed premises. The permittee has to have failed to take reasonable measures to prevent that felony. Multiple crimes or violations, administrative violations of Title 7.1 had to have occurred on the licensed premises in the last year. And finally, the continued operation of the permit presents a danger to the surrounding community. So I think we can all think of scenarios, particularly in Marion County and Indianapolis in the last 18 months, where there has been violence at a bar and the imminent removal of their operating capacity is necessary and appropriate to protect the public. So those are the factors. That's all I've put in here about this bill because it is that's all it is. And again, I want to emphasize that this is an authority that the ATC takes seriously in terms of its exercise. Obviously, delaying due process is not something that any state entity can take lightly, but there is post facto due process in this context. It is offered, obviously, and a full and fair hearing will be provided. It may happen at that third day hearing that the bar is allowed to reopen. But it all depends on the facts. We have questions on this one, MB?
Yes, we also have a couple of late questions from the prior slides. So the first one is from Tammy. Is the temp beer wine permit can receive and sell mixed beverage in effect now or July 1st?
That one might have an emergency effective date. Let me check.
Chris.
I got my bill open. Yeah.
That's emergency, so it's effective now.
Okay. Good call, Alex. I thought that was the case. That was a good question out there. Good call on that. Yep, you can do that now. Next.
All right. And then from Steve, can you sell spirit-based canned cocktails with a temporary permit?
I'm sorry, what was that?
Spirit-based canned cocktails with a temporary permit.
Yep. If they meet the definition of mixed beverages, then they're cool. And spirit-based canned cocktails are mixed beverages. Yep. And the definition of mixed beverages is in. I'm gonna put it in the chat. This is the code site reference for mixed beverages. That's where it's defined. Go ahead, MB.
Okay, this one is from Mark Schublock. What notice provisions will be implemented to the permittee or attorney under emergency suspension hearings? To rewind, what is the timing of the non-rule policy and the floor plan rule? So we got two questions there.
The non-rule policy will be out before July 1, the effective date. We probably will have hopefully mid-June. Let's just be realistic and so hopefully by mid-June. I hope it doesn't look much different than what we've got here, but I just always have to disclaim that fact. And then the other part was about the notice.
Oh no. So first off, excise officers will come out.
as well, probably. But I would say that the initial notice is going to be AT or the excise coming out and picking up the permit and delivering the notice in person.
Chris,
That's
I
the
had a
initial
hard time
notice.
hearing you on that, so do you mind? I think you cut out a little bit.
Oh,
Can you
sure.
repeat?
Yes. Was I breaking up?
Yes.
I said we'll hand deliver notice and we'll pick up the permit. That's the primary notification that'll be provided. Can you hear
Okay,
me
so
now?
we have another question about I think the exception to limited separation. So just to clarify, if a restaurant has a minimum of 100,000 of food sales annually, they are not required to have a structure or barrier that deters free access, like a partial wall or fencing. It could be completely open between dining and bar area,
If they get
assuming none of the
approval.
not available items apply.
Yeah, if you get approval from us, yes. You have to go through the approval process, but otherwise that is an accurate recitement of the law. Yep.
Okay, and I believe that is all the questions we've got so far.
Great. Should we answer that vending machine question for Scott? Let's see, what did he ask?
No,
Okay, go
I
ahead.
told him he could, since it's not related to a legislative change, we're not gonna take everybody's
Oh, I
time
see
on the
that.
legislative
Okay,
update,
cool. Sorry.
but that he
Good.
could submit his fact pattern.
Thank you. Okay, so let's move on then to another legislative issue here. We've got SCA 23, the county fairground permit. So what this is a new alcoholic beverage permit that is issued to local fair boards. So this local fair board permit allows an event that sells alcoholic beverages to occur on the county fairgrounds. So it allows approved permittees to serve alcohol at events hosted by the local board or unit at a county fairground. The permit held by the local board, if the county fairground is owned by a local unit, the legislative body has to approve the permit request made by the local board, and the local board has to hold the permit regardless of who owns it. So in other words, let's say that the county commissioners own the fairgrounds in your county. The county commissioners are not going to hold the fair board permit. The local board is going to hold that permit. If that's the case, if the local board doesn't, the legislative body of the local unit has to approve the request, and then the local board will make the request for the permit. Hopefully that makes sense. I was a little jumbled there in my initial presentation. So the terms of the county fair permit are the permit fee. It's $0. So hopefully that doesn't break anybody's bank. It's a 1-year permit and it's renewed annually. It allows the sale of alcohol by the glass for on-site consumption. And that alcohol served by the glass for on-site consumption is done by designated vendors that are existing permit holders, retailers or craft manufacturers. And minors may be present in the areas where alcohol is served. Those are the terms of the county fairground permit. And along the lines of number 5, you'll never believe it, but another exception to the limited separation requirement was introduced for county fairgrounds. So and the state fair. So now that is why you can have minors loitering there, because county fairgrounds have an exception to local limited separation. So those are the terms, and then I'm going to get into a little more detail on the actual application. So in order to obtain this permit from the Alcohol Tobacco Commission, and I missed maybe a step here, because first off, you got to determine on the local level, and this is a government, anybody here who's representing a county, a local fair board, something along those lines is relevant to you. If the commissioners or another entity within the local unit owns the fairgrounds, the first step is to get the local legislative body to approve the fair board requesting the permit. So that's step 1. If the fairgrounds are owned by the fair board, the local board, then they complete the permit application, or if they get approval, they complete the permit application, and in that application, they're going to list all of the designated vendors with their permit numbers that they plan to have authorized to serve alcohol at their events. They have to list the dates of all the events hosted by the local board at which the permit will be used. They have to have a floor plan for the area the alcohol is sold. And then they need to supplement that application after it's been approved or filed with any changes to the designated vendors, the add one if you remove one, any additional events or deleted events, and any changes to the floor plan, the area where the alcohol is sold. It's important to note here that this is not for, and actually back this on the next slide, this is not for private events. So the events under this permit can be used for events that are literally hosted by, all of the liabilities assumed by the local board, by the fairgrounds, right? So if you have a wedding, private person has a wedding on the fairgrounds, they're going to need to get a temporary permit, just like they do currently. And if they get that temporary permit, it's going to be subject to the stipulations around a beer and wine temporary permit, including 4-H limitations, which is to say, if there's a 4-H event going on the fairgrounds at the same time, you can't get the temp, right? Now that doesn't apply to the county, the local board permit. Local board permit is not subject to the 4-H restrictions. So that is an important qualification here. This permit cannot be used for private events. And if you are a local board, you need to really be diligent and deliberate in deciding when you use this, because you're going to be liable for anything that happens in conjunction with the use of the permit. So the permit requirements, local boards got to adhere to all the requirements of 7.1 and the rules. Alcohol can only be served by, excuse me, licensed employees certified under 7.1 through 1.5, and only between the hours of 7 and 3 a.m. There really needs to be steps taken to ensure that the alcohol is only served by designated vendors and only at events that are sponsored by the local board. Can't have individuals bringing beer in other words, and alcohol in, or serving their home brew or something. They need to be designated vendors and licensed permit holders. So some risk management suggestions, and this came from speaking at Excise Statewide last week, our statewide training. All of our fabulous excise officers were gathered, and I did the same presentation, and they gave me some great input. And one of the big things they're worried about is alcohol in the parking areas. So whether it be outside alcohol that's brought in and consumed in the parking area, or brought in from the parking area into the fairgrounds, and also alcohol being brought from the fairgrounds that was legitimately served and bringing it into the fairgrounds. So we don't want to see that. So make sure that there is clear posted signage that, no alcohol, no outside alcohol is allowed in the parking areas. And yeah, again, no alcohol from the event into the parking area. And then, we suggest, this is a required pursuant to the statute. Alcohol is actually allowed to move freely around the fairgrounds outside of the service area. But I think it would be wise, we think it would be wise probably to limit the movement of alcohol outside the service area in some way, certainly from getting into the parking area. But that is a discretion, left to discretion of the local entity to decide how to handle that. This is just a suggestion to limit risk. And then we'd also suggest that you have uniformed officers, maybe at the event in the parking area, just having a presence to, induce and encourage good behavior. So I want to also state that if there are serious and repetitive violations of 7.1, or the permit events get out of hand, well, we can revoke or suspend these permits. Obviously, that's not something that we're really wanting to do. We want to maintain great relationships with all of our local government partners. And I really doubt any bad stuff's going to happen with these, but I just want to make sure that it's all stated on the front end, and some suggestions are offered for risk management, just as a courtesy and to cover our bases here. So that is SEA 23. Does anybody have any questions about SEA 23?
Okay, it doesn't look like we have any questions about SEA 23.
Okay.
Valerie Teslow, she said she joined late, and I just want to know if I need to apply for the other tobacco certificate permit if I am a bar that sells cigarettes by the pack to customers?
You just need a retail tobacco sales certificate. You don't need a wholesale because you're not distributing alcohol to another certificate holder. Yeah, it's a three-way permit, this SEA 23. It allows for, yeah, full alcohol service by the permittees. So it's going to depend on the permit held by the vendor. So if the designated permittee has a three-way, then they can sell, all the above.
Okay, I
That's
do not
fair
think
enough.
we have
Yep.
I do not think we have any other questions.
Okay. Let's get on to SEA 89. This one is just new permits. How am I doing on time? Okay. This one is just new permits. They're all out quota permits, and this is the annual bonanza of new, essentially, redevelopment permits. So, new three-way restaurant permits. There are so many, I had to create 2 columns. So Cherville has 3 new three-way restaurant permits that are economic development area permits. This is the same as those Gary permits we talked about earlier. Lafayette, 3 new ones. West Lafayette, 3 new ones. Delphi, 2 more. Delphi has been mentioned in legislation from the ATC like the last 3 years. So there you go, Delphi. Bloomington has 2 new three-way restaurant permits. And then transit district permit. This is a whole new creature. So Michigan City has 8 new three-way restaurant transit district permits. And in economic development permit requirements, I talked about this really briefly with the Gary, but these economic development permits are premises that are located within a designated economic development or redevelopment area within the municipality. That's a $40,000 initial permit fee. It requires the written approval of the municipality at the time of application. So you, again, if you're an applicant, you need to go to your local government first. It requires written commitments from the applicant if that's required by the local ordinance. And then it's a non-transferable permit. So it's where it is, right? If you have a permit that's located at 1-2 Main Street, that's where it's staying. So if you want to get this permit or start the process of applying for one of these permits, you need to contact your municipality first, and you need to determine if your location is in a designated area, a development, redevelopment, or revitalization area. You need to obtain the written approval of the local government, and then if required by local ordinance, execute whatever written commitments are required by that local ordinance. I have reached out to all of these locations, all these municipalities. I've sent an email to the city attorney or a legislative body member, somebody. I got contacts from AIM, which is very, very helpful, and sent out some communication to all these municipalities, letting them know of these permits and giving them some basic instructions for how to get the process going, what to expect in terms of hearing from applicants. So they will be expecting you if you reach out. The new transit permit that's in Michigan City, it is a lot like the redevelopment area permits. The only difference is it's in a transit district. And this is NICTE up there, the Northern Indiana Commuter Transit Authority, I think it is. I'm not 100% if that's right. But the premises have to be located within a transit development district established by 36.7.54.5. 40 grand per initial fee, written approval in the municipality, written commitments if required, non-transferable. So all that's the same as the redev permits. Only difference is you got to be in a transit development district. The idea here is to get that corridor some commercial development, I believe. So the NICTE corridor, attracting some commercial development to that area is the goal here, I believe. So I definitely a good goal and I think a worthwhile pursuit if we can get some applicants and get some businesses going up there. So if you want to get started, contact Michigan City. And it's just like the other permit. You got to determine if you're in the right spot, get their approval, and execute commitments if needed. Any questions about the new permits?
I do not believe so.
Okay.
But we do have a question from Miss Lori Daly about the county permit. So county-owned grounds and liquor permit, grandstand is outside of the permitted area. Can local board get this license for the grandstand area only with commissioner approval?
Is it outside of the fairgrounds or? I didn't quite
Oh, it
track.
says grandstand is outside of the permitted area. And she wrote
Oh,
no.
oh, if it's on the fairgrounds, then alcohol can go to the grandstand, yeah. There might be a local ordinance that imposes some limitation on that I'm not aware of. That would obviously trump the permit allowance. Daphne, Daphne is a big 4-H'er and really knows a lot about the fairs. So Daphne, is there anything that you want to add on that?
No, as long as just a little question is if the liquor permit, if they already had a permit there that they were allowing, but if 4-H is present, they would not have been able to sell before. This would allow them to sell now, and they would have to get approval from the county if the county owns the land, is what my question was.
Okay. And if you're talking about an existing permit that is for the fairgrounds, if it's already has a permit there, you can't have two permits at the same location. So I would think that would be a limitation. We probably need to talk separate about your very specific circumstances because I bet you there's more to it and we could probably problem solve something. But as a general matter, alcohol can flow across the fairgrounds. Again, we'd encourage you to limit that and put a lot of clear signage around where alcohol can and cannot be. But grandstand can be part of it for sure if it's part of the fairgrounds and you otherwise qualify for the permit. So I would say if you have additional questions, reach out to us by email and maybe we can set up a time to chat.
And Chris, I have our second code word for CLE credit. Sticking with our wonderful racing theme, the word is pit stop.
All right. Thank you, Daphne. Pit stop is the word. Okay, so let's move on to SDA 144, the simplest of all of the bills from this session, and I'm not being sarcastic there. So vapor devices is what it's called, and vapor devices is what it does. So currently there is a word in Indiana code. I'm sure you guys are all familiar with it, and you use it every day, and it's part of your lexicon. It is vapor product, and of course, vapor product refers to just the device, not the actual product, because that makes sense. So what we did, because it doesn't make sense, is we changed the term we changed the terms vapor products to vapor device. So vapor product means the device, but now vapor product is called a vapor device. So vapor device means the device, and that's the device without the e-liquid. That's the change. And a lot of this, the goal with this change is to create transparency, obviously, but also because we use that word a lot in SEA 185. So that's part of the reasoning for that change. And again, a vapor device is the device used to consume the e-liquid, but without the e-liquid included, right? So a refillable without the e-liquid. And that term again was used to be called a vapor product, which didn't make any sense. And so this bill also prohibits advertising of the e-liquids within 1,000 feet of school property. That's any advertising. So if you have signage on your building and you're within 1,000 feet of school property because you have a grandfather, otherwise you're allowed to be, you can't do that. So no e-liquid advertising within 1,000 feet of school property. First offense, Class C infraction. Second offense, Class D misdemeanor. And then secondly, this bill did, I guess, one other kind of big thing here. Vapor device, I almost called it vapor product. Vapor device has a new age restriction. So previously, you could have theoretically purchased a vapor device without e-liquid, without the tobacco product, at any age. Now there's an age limit imposed. So you have to be 21 to purchase or possess a vapor device. And you have to, if you're a retailer, then you need to make sure that you're only selling vapor devices to people that are over 20 or 21 or over. Otherwise, you're going to have potential prosecution for Class B infraction. So it's a Class B infraction to possess or purchase if you're under 21, vapor device without the e-liquid, and it's a Class B infraction to sell to somebody under 21 if, the vapor device without the e-liquid. So that's all SEA 144 did. It was really a cleanup bill, and then the age restriction was imposed and the advertising limitation. Any questions on that one, Melissa?
Yes, we do have one question. Does the advertising apply only to e-liquids? What about
Yes.
devices or disposables?
It applies to, it applies to I believe it would use the word e-liquid. let me look at the code real quick.
Hey, Chris,
Yeah, Vargo, I thought you might have the answer. Go ahead.
it'll be e-liquid or vapor product. So it's going to be pretty
Wait,
encompassing.
vapor device, you mean?
No, the statute says vapor product.
Oh, but vapor product under 185 is the device plus the e-liquid.
Correct.
So that would not include just vapor device then, would it? So if you're advertising just the device, I guess you could still do that. Right? Fargo?
I would think so, that if you're just advertising the device, but I don't know how many advertisements out there would just be the device without any product in it.
Yeah, I don't either. Honestly, I hadn't contemplated, let's see, it says e-liquid or vapor product as defined by 7.17223. Go back to 7.1, 7.23. Yeah, that doesn't include the device by itself, although I think vapor product might include the device by itself. How about we just don't advertise any e-liquids or related stuff within 1,000 feet and we'll be good. But I'll confirm that because it's going to be in the next bill. Any other questions?
Yes, he has a follow-up. Can I advertise the vape shop itself without any mention of products?
The vape shop itself, huh? Alex, do you have an opinion on that?
I think you would be fine advertising your business as long as you're not advertising a specific product or drawing in specific people for that product. And to clarify the last point, the definitional change in Senate Bill 185 that Chris will talk about here in a minute does address the change in the term vapor product, which is referenced, and that includes both the device itself and the e-liquid. So you wouldn't be able to advertise the device at all.
Okay, I thought that was the case because I thought I got both of those. It wrapped up in that word. Thank you, Alex. Good follow-up. Thank you for that question. Great question.
And then we have a question from Ms. Lorianne Shelton, just to verify. It doesn't matter if the business is not specifically a smoke shop for the advertisement.
Yes, Lorianne, that's correct. The word here, let's see. Any medium. Yeah, no, doesn't matter. Doesn't even mention the retailer in here, Lorianne. And Lorianne is our tobacco processor, and she's really good at her job. So if you have issue with tobacco, as long as it's not involving a vending machine, reach out to Lorianne. Sorry. Okay, next.
And that's all the questions we have so far.
Okay, cool. Next bill is SEA 185, and this was really the big bill for us because of the implementation requirements, and it's a big bill for everybody, I think, in the industry. I really want to emphasize the partnership and the work that we did with all of our industry partners, all of the Indiana tobacco retailers, vape shops, wholesalers, the tobacco manufacturers. Everybody got together and was willing to give in order to get something done on this important topic, which is the regulation of e-liquid. So I think everybody gave up something in order to further the common good. And I guess that doesn't happen every day, when we're doing lawmaking. So I want to give a lot of props to our industry partners for their partnership and willingness to sacrifice a little bit of what they wanted in order to get a good bill passed. So the SEA 185, it introduces, I'm going to go over this first before I get to the permits. It introduced what's called a foreign adversary product ban. And this is a similar ban has been introduced by multiple states. So what this does is any e-liquid products that are manufactured or sourced from a foreign adversary cannot be sold in the state of Indiana unless that product has been approved or is pending approval by the FDA. So a foreign adversary is defined by the U.S. Department of Commerce, and I'm going to list them here on the next slide. The banned products in the code and throughout this presentation are referred to as foreign adversary products. So it's important to note that a foreign adversary product would be one that is not FDA approved or pending approval. Let's say that our goal here is to go after bad products, right? It's to go after dangerous unvetted products. Our goal is not to pick on anybody in particular in terms of like a nation or a source. The problem just is that a lot of these unvetted products are coming from, certain foreign adversaries, right? And so targeting the foreign adversary source is a helpful way to eradicate the worst, most dangerous products that are on our shelves. And also, the alternative, if we don't eradicate those products, pushing them towards obtaining vetting by the FDA, right? The FDA has a lot of resources and a lot of expertise. And if we can get those products vetted by the FDA, then that's all we're looking for is safety and some guardrails. So that's a fine outcome too. If we don't have to eradicate them, that's all the better. So the foreign adversary product is an e-liquid manufactured in or sourced from a foreign adversary nation that is not approved or pending FDA approval, as I said. This ban includes products that have ingredients sourced from these adversary nations as well, because again, these are unvetted ingredients, unvetted components. Does not include a vapor device without the e-liquid. This is important because I know a lot of the e-liquid the vapor device components, they come from China, and we aren't gonna touch those. They can still continue to get to get the electronic components, the batteries can still come from China. This doesn't touch that. We're not really in the business of regulating electronics, so not going down that road. Again, FDA approval or pending status that ensures that the products are vetted. So the current foreign adversaries, the following nations are designated as a foreign adversary under 15 CFR 791.4. So the People's Republic of China, the PRC, the Republic of Cuba, Islamic Republic of Iran, North Korea, Russian Federation. Most of the foreign adversary products are coming from China. That's just the reality, right? I would say all of them are coming from China. And those products will all be banned July 1, 2026, unless a manufacturer demonstrates FDA approval or pending status, right? So obviously, every manufacturer, doesn't matter where you're located, you're going to have an opportunity to have your products sold in Indiana if you can meet the threshold of complying with FDA diktats, right? So if you're a foreign adversary manufacturer located in a foreign adversary, owned by a foreign adversary nation or company located there, and your products become vetted by the FDA, or you already have a pending application, then you demonstrate that to the ATC and that product is marketable in the state of Indiana. In addition to the foreign adversary ban, we have the e-liquid manufacturing permit, and this is targeted at all e-liquid manufacturers, doesn't matter where you're located, if you're selling a product in Indiana. So manufacturers that are selling e-liquid products in Indiana must be permitted. Every e-liquid product sold in Indiana is going to require an underlying e-liquid manufacturing permit. So if product A is on a shelf in Indiana, that means that the manufacturer of product A has obtained a permit from the ATC and included product A in their permit application. And all Indiana manufacturers also required to be permitted, right? So even if you don't sell in Indiana, but you're located here for some reason, you're going to have to be permitted by us. To qualify for an e-liquid manufacturing permit, applicants have to comply with FDA product quality and production requirements. The products, examples, products cannot contain harmful and potentially harmful constituents, the HPHC, there's a list of like 96 HPHC on the FDA's website. You can find it quite easily if you Google it. The FDA actually has a lot, as bad as they've been about other stuff, they have a really helpful website and it's very easy to navigate and they've got a lot of resources on it. So I'd encourage those who have questions about what are FDA requirements. If you're manufacturing e-liquid, you probably should already know this, what the requirements are, but if you do have questions, explore that website. It's very helpful. And then another example of these requirements, you have to have you have to register your manufacturing facilities with the FDA. This doesn't mean that you have pre-market approval necessarily. When I say registration, that means that your manufacturing facility, it has to be registered with the FDA. This is a long-standing requirement of U.S. law. You manufacture tobacco products generally, you have to have your manufacturing facility registered. Manufacturers can obtain an Indiana permit for e-liquid products not approved or pending with the FDA by demonstrating compliance with FDA product quality and manufacturing regulations. The point here, the point here is that FDA approval or pending a status indicates that the product has been vetted or is being vetted by the FDA. It also demonstrates if it's approved by the FDA, then it's approved for interstate commerce, and the state of Indiana has no authority constitutionally to remove it from interstate commerce. And if it's pending FDA approval, that means it hasn't been rejected, it hasn't been denied, it hasn't been deemed to be of poor quality, and the state of Indiana is not going to interfere and intercede in the determination and the procedures of the FDA in reviewing an e-liquid product, right? So in those two situations, you can sell the product in Indiana because the FDA has either declared it to be acceptable or hasn't declared it not to be acceptable. And even if you haven't done either of those two things, you can still sell your product in Indiana and obtain an Indiana e-liquid manufacturing permit if you comply with all of the other manufacturing and product quality standards, right? So if you would qualify for an FDA approval if you applied for it, but you haven't, you can still sell in Indiana if you can demonstrate compliance. And that does not apply, obviously, to foreign adversary products. If you're a foreign adversary product that hasn't applied for, isn't pending approval or approved by the FDA, then you can't sell in Indiana. That's within the foreign adversary ban. So the Indiana e-liquid manufacturing permits are 2-year permits. There's a $3,000 initial fee and a $1,000 renewal fee. Applications have to contain full list of products manufactured by the applicant. So every product that is manufactured and sold in the state of Indiana, you need to identify that if you want that product to be on the green list and listed as marketable in the state of Indiana. The products that have not been FDA approved or are not pending FDA approval, you have to include all the ingredients for those so that we can go through and red flag any of those harmful components that might be contained in the ingredients list. Point being there that if the FDA hasn't vetted it, or if the FDA is in the process of vetting it, then the state of Indiana is going to have to apply the scrutiny to make sure that the FDA's harmful components list is complied with by the applicant. If the product is pending FDA or is approved by the FDA, you just need to provide evidence of that FDA status. So whether it be a pre-market approval letter, or it might be a discretionary enforcement status letter, or whatever proof you have to show that you are either pending or have been approved by the FDA, provide that to us for that product, for each of those products, and you will not need to provide all the ingredient lists for those products. And then if anything changes with regard to your FDA status, if it gets denied or if it gets approved, let us know immediately. If it gets denied FDA status such that it's not deemed marketable by the FDA, you have to then submit your full ingredients list to the ATC, and we have to review and determine if it complies under Indiana law. Probably not going to, because the FDA said that it's non-compliant with the FDA requirements. So permittees must also report new products during the term of their permit via the required annual e-liquid manufacturer report. So 7.1751.1K has long required. Currently, we have an e-liquid manufacturing permit. It's only for open systems, so it's very limited in scope. But open system manufacturers that are permitted in Indiana have always been required to submit a annual report that lists all new products, any changes in the ingredients lists that have occurred since the permit was issued. That's supposed to be filed annually. And so if any changes occur between year one and end of year two before you're going to file your renewal, report that in your e-liquid manufacturer report. New products, though, this is important to note. If a new product becomes available and you're going to sell in the state of Indiana in the middle of a permit term, you need to let us know and file a supplement that we'll provide either online so that product gets added to the green list. And then any changes in the ingredients, that also needs to be noted in that report. So the green list and foreign adversary products. So a green list is the list of the products that have an approved underlying Indiana e-liquid manufacturer's permit. So applicant applies for permit, lists 15 products that they sell in the state of Indiana. Those products are all pending FDA approval. They get added to the green list, right? Same applies for all of our applicants. Every product that an applicant includes in their application that satisfies the requirements will be added to the green list. And then that green list will ultimately serve as the comprehensive list of e-liquid products that are lawful for sale in the state of Indiana. So because of these permitting requirements not being effective until January 1, so we don't have to have an e-liquid manufacturing permit until January 1, 2027. That gives us time to implement, also gives manufacturers time to apply. Because of that fact, we're probably not going to have a full green list of all approved products until this time, maybe a little bit earlier, hopefully 2027, once we've had a chance to process and approve all of the applicants and get all those products into the green list. So products that are not on the green list, those are unlawful for sale in Indiana until an e-liquid manufacturing permit is obtained. Enforcement of this requirement for individual e-liquid products is going to be very narrowly tailored between now and early this time next year, right? Because we don't know what the full universe yet of lawful products is. So we can't go out there and start pulling stuff off the shelves if there's a good chance or any chance that it's going to be approved and lawful via this process, right? So between now and then, the only thing that the ATC can enforce is the foreign adversary ban, because that's effective July 1. So if there are foreign adversary products on shelves, those may be subject to targeted enforcement between now and early next year, July 1, excuse me, and early next year. But again, really TBD in terms of how we go about enforcing that, because we don't have a comprehensive list of foreign adversary products. We're still doing research in that regard. So, though, if you're selling e-liquids on the retail level right now, there's not a urgency in terms of like, oh, I need to know what I cannot sell. Right now, everything is the same as it was yesterday, because the permitting requirements don't come into effect until January 1, and therefore that green list as the governing body of what is in Indiana, what can be sold in Indiana doesn't exist yet. Hopefully that makes sense. So the foreign adversary products, the ATC, what we're going to do with this, as we identify foreign adversary products, we will post a notice or an advisory on our website. We might distribute it via our email list. We'll figure that out, but we want to make sure that we're communicating when we identify a foreign adversary product so that retailers and distributors have a chance to react and to pull those things off of their shelves or pull those things from their distribution inventory. If we identify a product as potentially a foreign adversary product, we will first verify that it is a foreign adversary product by virtue of determining whether or not it has FDA status. If we identify a product that is made in, let's say, China, and it's approved or pending FDA status, that's not a foreign adversary product. So it won't be subject to the ban, if that makes sense. So we are obviously going to do our due diligence to make sure that we're enforcing the law properly and that we're not impacting products that will be allowable for sale in Indiana under this law. So again, the ban on foreign adversary products is effective July 1, but it's going to be a process to get implemented and enforced. And as I said, we're gonna be diligent in how we get started. So outside of that massive e-liquid overhaul modernization, there's also some miscellaneous tobacco changes in 185. First off, to sell tobacco, if you're selling tobacco, excuse me, you need to ask for an ID if the person looks like they're under 40, just like we do with alcohol. So now an ID is required for purchases of tobacco. We also introduced, like with alcohol retailers, we introduced a prohibition on sleeping quarters in TC locations. Alcohol dealer. We prohibited sleeping quarters in TC locations. So let's say that you have a tobacco shop or a gas station, whatever, you're selling tobacco, you have a TC, you cannot have place in the back where your employees are sleeping and living, essentially. That's what we're going after here is these living quarters that the worst of the worst actors are using a lot of times with human trafficked individuals, traffic labor, sex trafficked individuals. It's a serious problem that needs to be eradicated. And I think every law enforcement entity, every state agency, we all need to do our part to attack the areas where we can, the places where people are vulnerable to trafficking or where we've identified potential trafficking. We need the authority to go after and free those people from their slavery. And that is the idea behind this prohibition on the sleeping quarters. Next, the wholesale provisions that are in HE 1052 are also in this bill. We've already gone over those. And then there's this cigarette buy down language, which is the loyalty program discount. So essentially what this is wholesaler or manufacturer, let's see, conversation by the cigarette manufacturer, excuse me. So the manufacturer offers the wholesaler a discount if they buy a certain number of cartons of a certain product, right? And that discount can then be included the price offered to the retailer. So you can take let's say a penny off of each carton. If you buy this number of cartons, that penny can then be taken off the minimum price that's offered to the retailer, the price that's offered to the retailer, and the retailer can in turn pass that price back to the consumer. That makes sense. So before, this was deemed to be price discrimination, and it wasn't allowed. We weren't allowing this in the distribution of tobacco products. The statute was updated, and now we are allowing the consideration of loyalty discounts in the minimum price offered to consumers and the price offered from wholesale to retail. In addition to those changes, the habitual offender status for sale of tobacco to minors and minor entry into a 21 plus TC location was reduced from 6 violations to 3. So now if you have 3 violations for sale of tobacco to a minor in a 12-month period, you're a habitual offender. If you have 3 offenses for minor entry into a 21 plus TC location in 12 months, you are a habitual offender. Whew, okay. Questions about SDA 185. I have 6 minutes left in the hour and a half. So that was pretty good, but we can go over with questions. No big deal.
Okay, the first question is from Tiffany Nichols. Will these products be taken off the shelf?
What is notice? What?
Will these products be taken off the shelf?
Oh, if a product is identified as a foreign adversary product that is not pending FDA approval or has FDA approval, yes, we will target those products for eradication, for seizure, for confiscation. Again, early in this process, we will use educational enforcement. We will give opportunities to make things right. Retailers opportunities to self-correct, right? But at a certain point in time, probably after a few months, we'll start doing eradication where we do take the products off the shelves. The ultimate goal here is to get dangerous, unvetted products of shelves, to get them away from consumers. And so, yes.
Okay, the next question is from Chris. Does this apply to both e-liquids and disposables?
Yes, an e-liquid includes a single-use or a multi-use product. So e-liquid under Indiana law is any e-liquid, any vape product. Yeah.
Okay, the next question is for Christine Markham. Will the green list be posted on the ATC website? And if so, where?
Absolutely. Yes, it will. And we will post it prominently, maybe on the front page at first, but otherwise on the tobacco page. We'll also share it with our listserv probably. So sign up for the newsletter, or if you're a TC holder, I think we might be able to email you as it is. So we'll probably do a regular, maybe a monthly, we'll email it out, kind of like we do with tobacco minimum pricing. We'll kind of figure that out, but yes, we will be very proactive in communicating that green list. And so yes, and if you ever have a question about a product, reach out.
Okay, and then the last question is, are there requirements for tobacco retailers to have documentation of their products that they buy from a manufacturer permit holder? Similar to wholesale records receipts, but documentation to show they purchased tobacco from a valid manufacturer.
That's a great question. No, the impetus, the onus is on the manufacturer to demonstrate compliance with the ATC. You just need to make sure that the product's on the green list. That's your
Chris.
obligation. Yeah.
Real quick, I think what Brett's question is getting at is, for invoice requirements, are retailers required to maintain invoices of where they purchase the product from as the manufacturer? And yes, under
yes.
751.1, retailers are still required to maintain invoices noting where they purchase the product from, making sure that's coming from a lawful wholesaler or manufacturer. So yes to your question.
Okay.
Couple
great.
other things.
Yeah. Okay, good. I was sorry on that. I misunderstood the question. Go ahead, Alex.
No, you're right. Real quick, we're having trouble putting the CLE form in the chat, so we're creating a link to where everybody can download it off the ATC's website and submit it that way. And then Sergeant Lynch advised me that the buy down is specific to packs of cigarettes for sale at retail,
Okay.
not at any other way. So just as a clarifying point. And then I don't know if we got to Mark's question in the question and answer regarding Senate Bill 5 or SEA 5, I'm sorry.
I didn't see that one.
I'll read the question to you. When we speak of a quote hearing within 3 days, is this a formal hearing on the record, or is it simply a meeting with a commissioner or a hearing judge?
Formal hearing. Full commission.
Okay,
Yep,
and then just so everybody's aware, the chat or the form has been put into the chat.
Cool. Good questions, guys. I really appreciate those questions. I see Chris K. I am very familiar with the Texas foreign adversary ban. That was part of our basis, part of what we utilized that as a pattern to some extent in our work here. And we're working with the Texas Commission. Fargo has made contact down there, and we're working with them. So your question is, distributors are selling Texas compliant disposables. Will these be allowed to sell? Absolutely. If it's a compliant, disposables are not banned. There's no prohibition on disposable vapes. They're not treated any differently than refillables. They just have to comply with manufacturing and product quality requirements. So they're treated the same. Now, if they're a foreign adversary disposable that doesn't have FDA status, then they will be banned. But Texas already, if they're legal in Texas, they're probably going to be legal in Indiana because we have a very similar foreign adversary.
Okay, I think that's all the questions.
Okay.
Okay.
Hey, Chris,
Yes.
I have our final word.
Okay, what is it?
It's milk.
Okay.
As we say in our house, go fast, turn left, and drink milk.
All right, very good. Daphne, you are clearly a Hoosier. Very good, guys. Well, thank you all for coming and participating. Thanks for all the fabulous questions and for being interested and proactive and trying to learn more about what we're doing and the change of the law. If you have any questions going forward, please email us. This webinar will be posted on our website and probably distributed to our newsletter listserv later today. So look for that recording to be posted, and everybody have a fantastic Wednesday. Oh, submit your CLE forms to Daphne. That's also important. See you guys.